If you're into real estate, and I bet you are if you're watching this video, then you've certainly heard of land and probably heard of trusts. But have you heard of land trusts? And did you know that they are one of the cleverest and oldest asset protection tools around? Hi, I'm Stuart Simone, founder of Simone Legal PC, and as a longtime real estate litigator and real estate investor, I've seen firsthand the importance of safeguarding your hard-earned real estate investments. So join me as we embark on a comprehensive journey into the world of asset protection using land trusts. First off, why do you need a land trust in the first place? Well, it's all about maintaining privacy and ownership and ensuring the comprehensive protection of your valuable assets. I remember hearing from a very successful and nationally renowned real estate guru who said, "You know you're going places once you've been sued." And it's true, especially when you live in California, the most litigious state in the union. If somebody is considering suing you, they'll be looking to see how deep your pockets are. And if they don't find any real estate, they might not sue you in the first place. And even if they did sue you, and even if they won, they might not find your property to collect from a judgment. So if you're a real estate investor, then you need to know about land trusts, as no other revocable entity offers more asset protection. Now, the history of land trusts. Very few people know that land trusts have been around since at least Roman times. They became popular during the time of King Henry VIII in England, when wealthy families used land trusts to hide their ownership of land so they would not have to serve in the military or fulfill other obligations of land ownership. The first land trusts in the U.S. were established in Massachusetts during the 1850s for the purpose of protecting small parcels of land for public use. The modern U.S. legal entity that we're talking about today, a title holding trust, was developed in the early 20th century by Chicago Title and is also known as the Illinois Land Trust. Illinois trust law and Massachusetts business trust law set the foundation for all other states to follow. This is the reason why most of these trusts today are referred to as Illinois-type trusts. Now, not every state allows land trusts, and only California, Florida, Virginia, Texas, North Dakota, Indiana, Hawaii, Arizona, and Ohio actually have statutes providing for land trusts. So, what is a land trust? Now that you know the history, let's learn precisely what a land trust is. A land trust is usually a revocable living trust, which means it can be amended or canceled during the lifetime of the grantor. While a basic vanilla land trust may be an ordinary estate planning trust, where the trustee manages the property for the benefit of a distinct and separate beneficiary, in Illinois, a land trust may be created for the sole purpose of putting the title to land in a third party. This type of trust is called a title holding trust. A title holding land trust, also known as the Illinois Land Trust, is a tool that aims to preserve the anonymity of the owner of the land. A title holding land trust is unique for two reasons. First, in a title holding trust, the property owner is both the grantor and the beneficiary of the trust, whereas most often in estate planning, the grantor of the trust is forming the trust for the benefit of separate beneficiaries. Second, in a title holding trust, the trustee merely holds title to the property and has no duty to manage it. In fact, the trustee in a title holding trust can only make transactions or significant decisions about the property when directed to do so in writing by the beneficiary, which is you. Now, land trusts versus living trusts. You might be curious about how land trusts differ from living trusts. Well, similar to a revocable living trust, title to the real estate is held by a trustee while the beneficiary of the property retains the ability to enjoy all the rights and responsibilities of owning the property. But one significant contrast is the role of the trustee, who is yourself and usually your spouse as well if you're married, in a living trust, but is a third party in a land trust. The fact that you are not the trustee is one of the primary features that gives you asset protection, as your name is not attached to the property publicly in any way. Unlike a typical living trust, it is the beneficiary of the land trust, not the trustee, that retains the right to end the trust at any time and transfer the property out of the land trust. You, the beneficiary, would have the ability to direct the trustee when to act and what actions to take in relation to the property. And it is you, the beneficiary, who can change trustees at any time. And while a living trust is typically used to hold your entire estate, including multiple properties if you own them. Each land trust relates to one specific piece of real property. Remember, when you title a property in a trust, the trustee's name will appear on the deed. But since a land trust trustee is a third party, your name will not show up. Even better, you can name the trust anything you like. Something totally random works best for asset protection. This, combined with the fact that it only relates to a single property, means that the modern land trust delivers focused protection and asset segmentation. Now here's something amazing. When real property, real estate, is placed into a land trust, the interest is essentially converted to personal property. A personal property is anything not attached to the ground, like clothes, auto, furniture, jewelry, even stock. And in this case, the property is legally treated similarly to stock in a corporation. Consequences of that characterization are that the property becomes simpler to manage and convey than an interest in real property. So you can see that understanding the legal intricacies and benefits of land trusts and the states that allow them can significantly enhance your real estate strategies. Unlocking the benefits of land trusts. Now that we understand what land trusts are and their legal standing, let's explore the myriad of benefits that they offer to real estate investors. Privacy. Privacy serves as the initial line of defense for asset protection. The less people know about you, the less of a target you are for a lawsuit. Land trusts were originally designed for privacy purposes. By placing your property into a land trust, you effectively hide your ownership and keep your name out of the chain of title. This is one of the main reasons to use a land trust as the first entity in a line of barriers to confound your enemies and your adversaries. After property is placed in a land trust and legal title is passed to the trustee, the identity of the true owner of the property is essentially hidden. That's because the deed in trust on record with the county indicates that the property is owned by the land trust instead of in the individual's name. Further, trust agreement is a private document, so the identity of the owner or owners is never seen by the public. Most other business entities, such as LLCs, corporations, and some partnerships, must be registered with a governmental agency. The registration process divulges the owners and exposes them to public scrutiny. Most states and California do not require land trusts to be registered. The only document the public sees is the deed, which does not reveal who the beneficiaries are. And the privacy of land trusts is a great benefit for more than just asset protection. Perhaps the most legendary land trust story involves the creation of Disney World. Walt Disney had to purchase hundreds of contiguous parcels of Central Florida land in order to fulfill his dream of Disney World. But if he had just told everyone what he was doing, there would have been many holdouts and slick negotiators who understood how important their little parcel was to the big picture. So, Disney used land trusts to discreetly purchase hundreds of parcels of land for it eventually became Disney World. For real estate investors with multiple properties or those involved in potentially controversial projects, privacy offered by land trusts can be a significant advantage in avoiding unnecessary public scrutiny. Asset protection. Privacy is important, but asset protection is usually the primary goal here. Land trusts shield you from the hazards of individual ownership and prevent judgments against one owner from becoming liens on the property. Moreover, land trusts can be fortified as effective asset protection tools by creatively including protected devices in the trust agreement. Consider using an out-of-state land trust to add an extra layer of protection. For investors dealing with properties in high-risk areas or prone to lawsuits, land trusts act as a protective shield, safeguarding their hard-earned real estate assets from potential legal threats. Ease of conveyance. Real estate investors involved in partnerships or joint ventures will find land trusts incredibly convenient as they allow for seamless property management and transfers. Conveying or mortgaging property with multiple owners can be complicated, but a land trust streamlines the process. Since all interests in the property have been transferred to the land trust, it is unnecessary to obtain deeds from every single beneficiary and the release of spousal homestead rights. Exposing to partial interests. A unique fact of land trusts is that they legally convert real estate interests from real property to personal property, making it easier to assign partial interests to other individuals. This includes assigning only part of the interest. Instead of transferring interest in the property by deed, interests in property held in a land trust are managed by modifying the beneficiary designations and rights under the trust agreement. This is much better for a large number of co-owners of a property that may frequently change, like a group of investors, than if the property is held outright in the names of the owners. Additionally, land trusts provide a viable option for real estate investors to pass on fractional interest to their heirs without undergoing probate. Succession of ownership, avoiding probate. Upon the original beneficiary's death, the property passes immediately to contingent beneficiaries indicated in the land trust agreement, bypassing probate. Yeah. Avoiding probate means your beneficiaries can quickly assume ownership of the property, avoiding the delays and costs associated with a probate process. Ease of administration. Revocable land trust is generally considered a grantor trust, like a living trust, and is considered to be a disregarded entity by the Internal Revenue Service. The beneficiary, whether it is an individual, corporation, LLC, or personal property trust of a revocable land trust, does not have to file a special tax return. Insuring your land trust is the same as insuring the properties that are held in your personal name, an entity, or another trust. The ease of administration offered by land trusts is particularly appealing to real estate investors with multiple properties, saving them time and resources. Let's talk about the creation of the trust. Now that we discovered the incredible benefits of land trusts, let's explore the steps involved in creating one. Begin by preparing a trust agreement with an attorney, such as yours truly, outlining the instructions for the trustee to hold title to the property. Remember, you as the owner will not be the trustee. Under the terms of the trust agreement, you, the owner, instruct the trustee to hold title to your real estate. Among other things, the trust agreement informs the trustee who has the authority to manage and control the property and who will become the new owner of the property upon your demise. Best land trust trustees are corporate entities that have a wealth of experience in their management, but a knowledgeable business partner or even a family member can do just fine. Next, draft a deed in trust signed by you and record it with the property's local county recorder, indicating the transfer to the land trust. To add an extra layer of anonymity, consider giving the trust a random name like the Stranger Things Bingeable Trust and only spelling out the last name of the trustee, for example, S.R. Simone instead of Stewart. The trust agreement is filed with the trustee and the necessary fees are paid. While setting up a land trust can often be a relatively simple procedure, it is imperative to involve an attorney experienced with them. A small, seemingly inconsequential error in its setup can create the potential for headaches down the road. To be revocable or not to be revocable, that is the question. The decision to form a revocable or irrevocable land trust is essential and should be considered carefully. While irrevocable land trusts offer much stronger protection, they can have adverse tax consequences. Remember, irrevocable means forever. Revocable land trusts provide more flexibility and still offer significant asset protection. However, if you do choose to form an irrevocable land trust, exercise caution to avoid creating a gift to the beneficiary, assuming the grantor is not the beneficiary, as this would create a taxable event. And the income tax rates for trusts are much higher than individuals. So definitely seek competent tax and legal advice if you're going to form an irrevocable land trust. Advanced techniques with land trusts. As seasoned real estate investors know, maximizing the benefits of land trusts goes beyond the basics. Let's explore some additional strategies and advanced techniques to take your asset protection to the next level. Combining land trusts with other entities. By combining land trusts with other legal entities like personal property trusts, LLCs, corporations, and your living trust, you can unlock additional layers of protection and tax benefits. Additionally, using land trusts in conjunction with entities in different legal jurisdictions can further enhance your asset protection strategy. Insurance and land trusts. Insuring your land trust is just as crucial as insuring the properties themselves. Accurate reporting of the land trust name to the insurance company is essential to ensure claims are honored in the event of a covered loss. Keeping your insurance policies up to date and aligned with your land trust is a critical aspect of the comprehensive asset protection. If the exact name of the land trust is not reported to the insurance company, then they could deny the claim when a covered loss occurs. So always make sure the name of the land trust is an exact duplicate of the name insured on your insurance policy. Some expert advice for maximizing land trusts. While land trusts are a powerful tool, navigating the complex legal legal and tax implications can be challenging. By understanding the intricacies and potential pitfalls, you can ensure that your land trusts are optimally structured for the best possible asset protection. Seeking expert advice from experienced attorneys and tax professionals is highly recommended. So in conclusion, land trusts, the ultimate revocable asset protection tool for real estate investors, offer an array of benefits that can significantly enhance your real estate ventures. But remember, it's vital to consult with an attorney experienced in land trusts such as yours truly to ensure it's the right move for you and everything is done correctly. Well, I hope you enjoyed this video, and I look forward to talking to you about living trusts, land trusts, asset protection, or estate planning. Have a great day.